Hi, I'm Amy Cornell. I'm your Texas broker for Front Real Estate, here to help you real estate better. So, worst comes to worst, sometimes you got to terminate a contract. So, we did all this work, we got under contract, and then for whatever reason, the buyer is wanting to opt out. And I will tell you, most of the time when we're terminating the contract, it is the buyer opting out, not the seller. But there are a couple of ways that the seller could terminate, and that would be on a different form. It would be that notice of seller's termination of contract. Like I said, very rare, so it's not something that we spend a lot of time on. What we spend more time on is the notice of buyer's termination of contract. So I wanted to show you that form. And really there's two forms that I want to talk about today. So the notice of buyer's termination of contract is a TREC form, and it's saying, hey, the buyer is choosing to terminate based on one of these things. Normally you're going to see paragraph number 1 that says, hey, per paragraph 23, buyer's not going forward. So the option period. Number 2 could be the third-party financing addendum. It could be that there was an issue with property appraisal. Could be that there's an issue with HOA. Could be that there's an issue with, hey, you didn't give me the seller's disclosure. Could be an issue that another issue with the appraisal. Could be an issue of paragraph 6D, the time to cure thing where it has those number of days that you have to review the title commitment survey and any exception documents. So there's a lot of ways for the buyer to terminate the contract. They can choose any of these, and that will terminate the contract. However, the seller has not signed that form. That is just signed by the buyer. And what the title company is going to want to have really as more of a CYA for them, which I don't love, y'all, but they are going to normally require this release of earnest money form. This is a Texas Realtors form. It is not a TREC form. It is really not required as I read it. You know, if we're terminating the contract during the option period per paragraph 23, and it's very clear the email was sent to the listing agent, the seller, the title company, everybody got that termination of contract before that 5 o'clock deadline on the last day. To me, this release of earnest money form is totally unnecessary, and really it indicates that the seller might have a chance to negotiate who the earnest money gets delivered to when they don't. And that's why I just don't love this release of earnest money form. I don't love that the title companies are requiring it, but I'll tell you, I see it over and over again. And rather than continue to fight the system, honestly, I'm just giving in and going ahead and getting that release of earnest money form signed. So if I have a buyer that wants to terminate, even during the option, I'm going to check box number 1 on the notice of buyer's termination. And then on the release of earnest money, I'm going to go ahead and fully fill it out. I'm going to have that the full amount of the earnest money goes to the buyer. We're going to sign it, and we're going to deliver both of these forms to everybody. Listing agent, seller, if there was an email address or address provided per the notices paragraph in the contract. The lender, if there was an attorney, anybody that I know of, I'm going to copy everybody on that. I'm going to make sure that it's via email, so it's time date stamped, as I want to make sure that everybody got it as of that time. When the seller receives that release of earnest money, best form is for them to just go ahead and sign it and send it back. So if you're representing the seller, they should go ahead and do that. But it does call to question, like, do they have any sort of rights to it? And there are some ways where there may be a termination of contract where the seller does have rights to the earnest money. It's a negotiation at that point. So I'll tell you, this is where we get into that practice of law. This is beyond what real estate agent can advise a client on. And so a lot of times this quickly gets into a situation where you need to advise the buyer or the seller to say, hey, I've taken this as far as I can. If you believe you're due the earnest money, or if you do not want to sign this release of earnest money form, you need to get with counsel. Okay. And the reason why I say that so quickly is because I want you to read this part up at the top in bold. Notice this form provides for the release of the parties, brokers, and title companies from all liability under this contract, not just for the disbursement of earnest money. Do not sign this form if it is not your intention to release all the persons signing this form from all liability under the contract. Read this release carefully. If you do not understand the effect of this release, consult your attorney before signing. I cannot explain with enough detail about that. That's why this says contact your attorney. I have a lot of agents that are like, but how do I say it? Well, yeah, but how would you say it? Well, all I would say is, hey, you have to contact an attorney. And I know that doesn't feel like, hey, that you're providing the best quality service for your client, but sometimes that is the answer. That you've really got to encourage them, hey, if you're uncomfortable with this, if you want to leave a back door open so that you can sue the other side, you may not want to sign this part, because if you do that, this releases all of it, which is another reason why I don't think it's fair that the title companies require it if you're terminating per paragraph 23. Again, I'm not the title company, so I don't really have the power for it. So it has that in bold, and then it has another line item underlined. The undersigned buyer and seller release each other, any broker, title company, and escrow agent from any and all liability under the aforementioned contract. The thing that I don't love about this form is that it has us as brokers sign it, which you as, well, for the agents that are with Front, you as an agent can sign it. We have power of that through our brokerage policies and procedures, but you may have to have your broker sign it. I just don't love that really the brokers signed this, but they're not a party to the contract. So it just doesn't seem to make sense all in that this form is out there. But again, it's the best that we have right now, and it is what our association attorneys have prepared for us to use. So just know, if you are terminating a contract, use both of these forms. That release of earnest money will fully release. So, if your buyer wants to have any sort of claim against the seller or anything down the road, that's not going to be possible because this is a full release. But it does achieve that goal of really getting the contract totally done, wrapped up, so that way that property can go back on the market and be sold to someone else. And so that then that buyer can have their earnest money and go back to doing whatever they need to do on the other property, or on another property, hopefully. So I hope that makes sense. Like I said, it is a big deal to get it time stamped, to get it into everybody's hands, by whatever deadline you're on, to make sure that it is clear that, hey, this contract is terminated and we're not going forward. I hope that helps. If you have any questions, let me know. Or like I said, don't be afraid to seek counsel, because you're getting into a legal issue very quickly on it. All right. Hope that helps.